Hunter Biden and his botched plea proceeding. We have the transcripts now that it has been completed. But before we look at the transcript, I want to share with you the parties who are involved in this. Christopher Clark is Hunter Biden's lawyer. Hunter showed up there in person. Of course, he's the defendant in this case. One of them is supposedly a felony for the gun charge, and the two others were misdemeanors, but we're in federal court, Judge Norica's courtroom. And the documents came out. We got to see in detail what the Hunter Biden plea memo looks like. And you can access all of these documents, robertgovea.com, sign up for the mind map. You can click this paperclip and get access to it. But we're not going to go through that document because they go through it in detail in the plea proceeding. And the plea proceeding, the other party there is from the U.S. government. This is Leo Weiss, the so-called government prosecutor from the Department of Justice, who's supposed to be pursuing justice, pursuing people who are all on an equal playing field, screaming at all of us that nobody's above the law. Well, going to be very interesting to see what his position is, almost arguing for Hunter's plea deal on behalf of Hunter. And all of this is taking place in Judge Norica's courtroom. And we go right to the transcripts. Here's what happens. United States of America versus Hunter Biden. District of Delaware, out of federal court, the date, July 26. The judge is Judge Norica. Everybody's there. For the United States government, we've got Benjamin Wallace, Derek Hines, Leo Weiss, who's going to do most of the talking. And let's not forget their names. These are the people who crafted and stood behind this deal and tried to squeak it through, all at the Department of Justice. And their bosses, a lot of questions for them. And their bosses, like Merrick Garland, who said that this was all above board, we've got questions for them too, and what the consequences are for all of these people. But this is the defense for Hunter. Clark Christopher, along with Berger Harris for the defense. Court is in session. All rise. Judge Norica presiding. All right, well, please be seated, everybody. Put your phone away. Okay. The judge takes the bench. She says, all right, good morning, everyone. Please be seated. All right, let me just start by reminding everyone that there is no recording of these proceedings that is permitted here. For those of you in the back, you are certainly permitted to watch back there, but we will not have any disruptions. Any disruption or attempt to disrupt will result in the court security and the marshals escorting you out. All right, with that, judge points to the prosecutor, Mr. Weiss, supposed to be prosecuting Hunter. He says, good morning, Your Honor. Leo Weiss, Derek Hines, Benjamin Wallace here on behalf of the United States government. Now is the time the court has set for an initial appearance in the criminal information filed in the United States versus Robert Hunter Biden, charging Hunter, and we have this format that we're going to have to bounce around on, charging Hunter with a firearms offense and for the entry of a guilty plea to the criminal information filed in a separate matter. He's got 2 counts, failure to pay taxes. The prosecutor tells the judge, parties are ready to proceed. And so, Your Honor, I ask permission to pass up an executed version of the plea agreement in the tax case. Judge says, you may. Thank you, prosecutor. And my understanding, Your Honor, is that we're going, Your Honor, first we'll conduct the initial appearance on the firearm charge, and then you're going to turn to the plea hearing on the tax charge. Judge says, no, hold on. Let me just take a look. She's flipping through the paper. All right. She's looking around. Prosecutor's over here at the prosecutor's table. So she looks up to Hunter and his defense table. Good morning, Mr. Clark. Mr. Biden. Defense says, good morning, Your Honor. Okay, so just so that we don't have that feeling that you need to be popping up and down over there at the defense, judge says, I'm fine if you want, when I'm asking questions, you can just stay seated. You don't have to keep popping on up over there. Defense says, okay, well, we won't do it any other time. Judge says, okay, thank you. Okay, so we do have 2 cases here. One is a criminal action based on a felony information gun charge. The other is a criminal action based on misdemeanors and taxes. Now, this is Biden's first appearance, so I had planned to conduct the initial appearance on the 2 cases at the same time. Just get them both out of the way at the same time. Any objection to that? Government says, no, Your Honor, thank you. Defense, no, none, Your Honor. I thought it might be a little bit more efficient and save some time. So she turns to Hunter. She says, Mr. Biden, in criminal action here, you've got charges about firearms under violation of U.S. law. Do you understand the charges that are pending here? She gives him all the different codes. You've also got a charge of failure to pay taxes, all the different codes. Do you understand the charges that are pending here, Hunter? Yes, Your Honor. Do you understand that the maximum penalties for this gun charge are 10 years imprisonment, a $250,000 fine, 3 years supervised release, and a special assessment of $100? Biden says, yes, Your Honor. And do you understand that the maximum penalties for each of counts 1 and 2 of the tax case are 12 months of imprisonment? And you understand you got to pay all this stuff if you plead guilty, maybe? The maximum penalties. Now, not saying what you're going to get, but just be advising him of the max. You understand this? Yes, I do, Your Honor. All right. Now, Mr. Biden, you have the right to be represented by a lawyer in these cases. That means if you can afford to, you can hire one of your choice. And if you can't afford a lawyer, you might ask the court to appoint one for you. Do you understand that? And obviously, his lawyers are like standing right here. They're like, what are we, chopped liver here, Judge? What is this? But the judge has to advise him. You understand that? Biden says, yes, Your Honor. All right. Now, you're presently represented by Mr. Clark, do you wish to continue that representation? Biden says, yes, Your Honor. All right. Now, Mr. Biden, you have the right to a preliminary hearing in these cases. At that hearing, the government would have to provide and produce sufficient evidence to show that the crimes with which you are being charged, that there's probable cause that you did them. Now, at that hearing, you would have the right to introduce evidence and cross-examine them. Do you understand that? Yes, I do, Your Honor. All right. Now, I understand that you intend to plead guilty to the tax charges. Do I have that right? Yes, Your Honor. All right. Do you understand that if you plead guilty to those charges, you're going to be waiving your right to have that hearing, the preliminary hearing? Biden says, yes, Your Honor. I also understand that the plan for the gun charge is a diversion agreement. Counsel, do we need to do anything regarding a preliminary hearing at this point in light of this planned diversion agreement? Prosecutor says, no, Your Honor. They're all like, wow, this is going great. We're right on track here. Amazing. We're going to get this thing through. Defense is like, we're in agreement with that, Your Honor. Nothing else we need to do on that. Perfect. They're sweating bullets. Judge says, all right, Hunter, you are not required to make any statements to the authorities. If you had already made statements to the authorities, you may stop, may not make any more. If you start to make a statement, you change your mind, you may stop at any time. And any statement that you do make, it may be used against you. We're in court. We're on the record here. Do you understand all of that? Hunter says, yes, Your Honor. The court and the judge. Okay, well, now pursuant to the Due Process Act, I confirm that the government, just making sure you know that you've got a continuing obligation to give Hunter Brady material, all of the exculpatory material. You understand that, government? Government says, yes, Your Honor. Has all the Brady material been produced, been given over to Hunter? The government says, yes, Your Honor, it has. And we're asking ourselves, really? It has? Has there even been a real investigation here? Feels like not, because you missed a bunch of the other charges that we've all seen on display, unfortunately, all over the internet. So the judge says, okay, defense, do you have any concerns about them not giving you exculpatory information? Of course, the defense says, none whatsoever, Your Honor. No. What exculpatory? This whole plea deal's exculpatory for my client. I don't care. The court says, okay, thank you. Okay, now how about pretrial release? What is the government's position on this? So the judge has not accepted the plea deal or anything. She's doing this one step at a time. She's going through the arraignment, right? Making sure he knows what he's been charged with, what the maximum penalties are, what could happen, all of these things. Do you have a lawyer? Yes or no? All standard stuff. So what about pretrial release? Is the government going to ask for him to be held in confinement at the end of this arraignment? Now, right after the arraignment, theoretically, they were going to enter a plea deal, and then Hunter would be free to go because his plea deal's like, you have a misdemeanor, and then you get a free ticket to Disneyland, which Hunter would love these days, especially New Disneyland. Such a great deal. The idea is that there would not be any need for release conditions because he's just going to walk out of there. So the judge is asking this as a formality. Government says, well, the conditions that have been recommended, we agree with. Defense, any concerns? No, Your Honor. We're in accordance with that. And she says, well, gosh, you defense attorneys, you just can't help yourself. You're just going to keep jumping up, aren't you? He says, I was taught at a hard school. I know. Judge says, I couldn't even think if I wasn't standing up. Says, okay, I understand that pretrial release, I agree. Pretrial release is appropriate, subject to the following conditions, which I'm going to read. So I'm going to release you, Hunter. And Hunter's sitting there like, well, I thought we were going to do this plea right after this. They still don't know that this thing's about to go awry. The defendant, they say, must cooperate, DNA sample, pretrial services, contact them, appear in court if you're convicted. I also impose any other release conditions. Says Hunter, sir, you must submit to supervision by reporting to the probation officer for pretrial services. You must continue to actively seek employment or continue it. I was hoping for a little clarity on money laundering fake artist who makes mucus COVID paintings. Does that count as employment? I don't know. You must communicate in writing all international travel plans and provide supporting evidence to get that approved. Why do you need to travel? If requested, you must not possess a firearm. You must not use alcohol. You must not use or unlawfully possess any narcotic drugs unless prescribed by a licensed medical practitioner. I will clarify, however, that marijuana is not legal. So tell that to your bong lawyer in California. And you are prohibited from using marijuana regardless of whether it's legal in the state in which you're prescribed, even if it's a medical practitioner. So no marijuana for Hunty. Now you must also submit to testing for a prohibited substance if required. If your pretrial services officer demands that you've got to test something, you've got to do it. Hunter's sitting there. He's like, oh crap. Hunter is sweating now. He's just like, oh gosh. Well, there goes my plans for this weekend. What am I going to do? Testing may be done with random frequency and may include urine testing, the wearing of a sweat patch, remote alcohol testing, any other form of prohibited substance screening or testing. You must not obstruct, attempt to obstruct, or tamper with any of these things. And she says, all right, just give me a minute here. Give me a minute. Reading through it. She's looking at that checklist. She says, gets to the checklist, substance abuse program. Yeah, and you must participate in a program of inpatient or outpatient substance abuse if directed by pretrial services. I'm going to put that on there. You understand those conditions, Hunter? Yes, Your Honor. He's like, So the court says, all right, any objection or any comments on these conditions? The defense says none from the defense, Your Honor. Government says nor from the United States. All right, Mr. Biden, violating any of the conditions of release may result in the immediate issuance of a warrant for your arrest, revocation of your release. Do you understand all this? If you screw up while you're out? Yes, Your Honor. Anything I left out that we need to address from either side? Defense, government? Not from the government. No, Your Honor, not from the defense. Okay, now we have two cases and two agreements here before me, and I understand the diversion agreement, which is the one for the gun charge, is not something that is typically before the courts, but you all did send it to me, so I do want to talk about it a little bit. Judge is like, absolutely prepared. This judge has thought this through about 12 steps ahead, just so we're clear as we go through this. When we zoom out on this, all of these questions that we're about to hear from the judge, she's basically setting them up. They're called tripwires. She's going to set them up because she's going to come back to that principle an hour later. So there are some provision in some of those agreements that are not standard and a little different from what I normally see. So I think we need to walk through these documents and get some understanding of what's being proposed so that I can give due consideration to the determination that you're all asking me to make. And so I want to start with the criminal action involving the tax charges. Okay? Turns to Hunter. Now, Mr. Biden, you told me that you intend to enter a guilty plea in those cases. Correct? Those cases. Yes, Your Honor, he says. So it's my responsibility, Hunter, to make sure that the plea is voluntary and that it's knowing. And in order to do that, I first need to ask you a series of questions. Before I ask you those questions, I'm going to have you placed under oath to answer those questions truthfully. It's important you do answer those questions truthfully because if you don't, any false answers may be used against you in a separate prosecution for perjury. Hunter, do you understand that? Yes, Your Honor. Defendant says, yes, Your Honor. All right. Mr. Buxton, please swear him in. He's sworn. Thank you, sir. Please be seated. All right. Now, Hunter, if at any time you want to confer with your lawyers when I'm asking you questions, you may. Just let me know, okay? Thank you, Your Honor, says Hunter. Hunter, how old are you? 53 years old, Your Honor. How far did you go in law school? How far did you go in school? Law school, Your Honor. When did you graduate from law school? 1996. You're a member of the bar? Yes, Your Honor. Any particular? District of Columbia and Connecticut? Thank you. And you speak and understand English? Yes, Your Honor. Are you currently or have you recently been under the care of a physician or a psychiatrist? No, Your Honor. Have you ever been hospitalized or completed hospitalized or treated for any mental illness or addiction to narcotic drugs of any kind? Hunter says, I have attended treatment facilities for addiction, Your Honor. Okay, so that was included in my question, which is treatment for addiction to drugs. So that was where I already asked you that. Okay. Yes, Your Honor. So I need you to tell me about that. Now, how many times have you, to the best of your recollection, been treated, whether inpatient or outpatient? Hunter says, beginning in 2003 with the inpatient, Your Honor, I have been, I believe, to close to 6 inpatient over the course of 20 years. Judge says, all right. And I also have been in outpatient programs also during that time. Hunter's lawyer, Mr. Clark, stands up. Your Honor, just to be clear, it's numerous, Your Honor. Like a lot. Held up like a phone book. He's like, look at this thing. Look at my intern with a wheelbarrow. The court, the judge, says, okay, well, look, I know it's a lot. I'm not going to walk through every single one, but I just want to make sure I have some understanding. All right. So, all right. Now, sir, Hunter, each time that you were treated in an inpatient facility, what was it for? Hunter says, for addiction to alcohol, primarily originally, Your Honor. Okay. And have you ever been in an inpatient program where you were treated for something else other than alcoholism? Drugs also, Your Honor. Okay. And I'm just not sure how these programs work. I'm sorry. Is it for any particular drug that you're treated, or is it just sort of? No, says Hunter. She says everything. Hunter says everything, Your Honor. And I'm pretty sure the judge knows all about these programs, just to be clear. Okay. And when was the most recent time that you were in treatment, Hunter? Well, are you currently in treatment for your alcohol or drug issues? No, I'm not, Your Honor. When was the last time that you were in treatment? I believe the fall of 2018. Defense says, I think that's right, Your Honor. Okay. Hunter says, Your Honor, sorry. That's okay. So the fall of 2018, and was that inpatient or outpatient? Fall 2018. Hunter says inpatient, and then also outpatient. Okay. And when did you complete that program? Or did you leave that program prior to completion? Did you finish it or did you leave early? I completed that program, the inpatient portion of it, Your Honor. And the way these programs work is you sort of go at higher levels of intensity and then you step down to lower levels of intensity. So it's very intense. You're inpatient, you're living somewhere, you're locked away from the world, and then you eventually go to outpatient and step down to maybe living on your own. So intense to less intense. So we don't know if he completed the outpatient portion of it, but he says I completed the inpatient. Okay, the judge says, and after you completed that program, did you then continue to use drugs for some period of time? I did, Your Honor. All right. So when was the last time? Okay, so fall of 2018 was the last time you received any treatment, right? Yes, Yes, Your Honor. And when was the last time that you used, ingested, or were under the influence of any drug, legal or illegal medication, or alcoholic beverage of any kind, including dime bags at the White House? Hunter says June of 2019, Your Honor. All right. And so just to be clear, you're not presently under the influence of any drug or legal or illegal medication or any alcoholic beverage of any kind right now. Is that correct? No, Your Honor. And this is a standard question, by the way. It's not just Hunter's a crackhead, so she's asking him. This is asked every plea. Okay, well, let's just be clear because, you know, people might look at this transcript. Oh, busted by the judge. You're right. We are looking at this transcript. You better believe it. We're looking hard. Said, I said, is that correct? And you said no. So let's back up on this. Hunter says, I'm sorry. Yes, Your Honor. Excuse me. And sir, do you understand what's going on and why we're here today? Hunter says, yes, I do understand. Lawyer for Hunter, do you have any doubts as to your client's competence? Hunter's lawyer says, none whatsoever. Any concerns from you, Mr. Prosecutor? No, none from us. Okay. All right. Well, based on that information that I received, Mr. Biden, I find that you are competent, you know, legally competent and capable of proceeding here today. So now I want to talk about the misdemeanor information, which contains, and the misdemeanor information is the document that is what initiated all of this. It's the charging document, which contains the tax charges that you're pleading guilty to. Have you received a copy of the information against you? The document. Have you seen the document? Just substitute the word information, substitute the word indictment for it. It's just a different process. It's not at all like an indictment, but it's the same mechanism. You've seen it? Yes, Your Honor. Have you fully discussed those charges and the case in general with Mr. Clark, your lawyer? Hunter says, yes, Your Honor. Are you fully satisfied with your lawyer's representation and any advice you got from him in this case? Yes, Your Honor, I am. Hunter, you have the right to have that information read out at this hearing, where we'll literally read the whole thing, but you can also waive that reading. We don't have to. Would you like me to ask the government to read it, or do you waive that? Hunter says, I waive that, Your Honor. All normal. Okay. Things are on track. It's like, wow, this is great. Like, we're getting through this, baby. Whew! The judge says, okay, now I want to go next to the memorandum of the plea agreement, which was handed up to me. Now, first, let me ask counsel, the government, prosecutors, so-called, what provision of the rules is this plea agreement being presented under? Lots of rules in law. Not only do you have the criminal law, right, the statute that was violated, but then we've got rules about how we go through the process, like rules of criminal procedure, and then rules have different local rules, and you've got federal rules of evidence, and there's all these different rules. So we're just going to simplify it here. It says, Your Honor, this is a B plea agreement. Okay. And just so we're clear about this, the judge says, I think, and I thought that probably was a B plea agreement. Mr. Clark, Hunter's lawyer, do you agree with that? It's a B? I do, Your Honor. Okay. Well, all right. Just so we're clear, this is not a C plea agreement, which is often called a C plea, which binds me to impose a specific sentence if I accept the plea. Is that correct? They both agree. Prosecutor, yes, it is, Your Honor. We agree. It is, Your Honor. So in your view here, well, what is my role? Since this is not the usual deal, what is my role in this plea? She says, well, I'm used to this other format. I don't see this regularly. Mr. Prosecutor, can you help me understand this, please? Judge, Your Honor has two roles, as Your Honor has already begun to determine that the plea is knowing and voluntary, so you check that box off in the rules. And your role is also to apprise the defendant that you're not bound by the recommendation of the government in this case. And the judge is sitting there going, that's it? That's all I can do? So that's all I can do. Like, this is the government saying, that's it? The government says, that's it, Judge. That's all you got. You're already done. All you had to do was make sure he was knowing and voluntary. You're not bound. You've done both of those things. And the courts, I can't even imagine what she's thinking right now. She's probably furious. Okay, she says, talking to him like a law school student. Now, is it my role to accept or reject the plea? Is that what I'm supposed to do now? You're going to tell me? It is not, Your Honor. Now, is it my role to accept or reject the plea? I don't even have this power. It is not, Your Honor. You don't accept or reject this plea. So then she goes back to the prosecutor. Well, okay. Well, I'm confused now. Now, let me ask you this, Mr. Prosecutor, so-called. Would my role be different if this were a plea under subsection A? Yes, Your Honor, it would. And how would you say it's different? Little Socratic investigation here. Well, the prosecutor's ready for this one. It says both A and C pleas require the court to either accept, reject, or defer on the plea agreement itself, not on the plea which is governed by, like I said, a separate provision of the rule. And so the court's role is just to accept, reject, or defer. The judge says, all right. Now, I do want to talk about that a little bit further. So what she's doing, she's just laying him down, right? She's getting his position right now. So I'm not going to spend a lot of time breaking this down because the judge is going to slam this back. We'll come back. All right. Well, I do want to talk about that a little bit further. But when we talk about the plea, but you can sit down for now. All of the foundation's been laid. Wait, she says, hold on. Let me ask you this. If it's an A plea, what is your understanding of the factors that I need to look at if it's an A plea. What do I got to do? Prosecutor says, well, so the rule itself, Judge, is silent on the factors. Judge was waiting for that. But the case law suggests that the factors, that the rejecting or the accepting of the plea would relate to the court's traditional role at sentencing. And so if, for instance, the court thought the charge bargain, which is what A does, if the court thought the bargain did not adequately reflect the seriousness, then the court could reject the charge bargain. And here's the court says, he's spouting off a bunch of crap. The judge says, look, when you say charge bargain, you mean the bargain by which the defendant pleads guilty and the government agrees to not bring other charges or to drop the charges that have already been brought. So there's a benefit, right? There's a reason for the defendant to plead. He's getting a benefit of the deal. Exactly, Your Honor. Okay. And in looking at the A plea, what I need to consider, or are those factors that you just sort of talked about, is that usually referred to as in the interest of justice? Is that what you're talking about? He's playing dumb. They are, Your Honor. Okay, great. Thanks. So you can be seated now. So thanks for clarifying that for me. And he's like, man, I nailed that one. I hit that one a home run. She asked me questions, factors. I said case law. I knew the case. Okay, great. Judge says, okay, so yesterday I received from third parties, this was from the House Ways and Means Committee that they tried to illegally remove off the docket. Judge says, yesterday I got a letter from third parties, almost 900 pages of attachments in one case, and a memo of law with hundreds of more exhibits. Says, I have not had time to read those submissions. I understand that there is some objection to them, and I'm going to give Hunter and the government, if it wishes, an opportunity to respond to those. But even though I've not been able to review that tranche of documents, I do understand that they request from Congress that I reject the plea agreement based on information that the filers submit cast doubt on the investigation performed or the charges brought or both. So the judge says, I got this big stack from Congress. So she goes to both parties here. Supposed to be adversarial. In most cases, the government prosecutors, they want to get the max against the defendant, and the defense wants to get the minimum and get the max benefit out of the government, called adversarial system. So she says to the judge, she says to both people here, so let me ask you this. If I were to think that the facts presented in those submissions that came over from Congress, or even the facts that have been presented to me in this case and the attached agreements, if anything I see suggests that the investigation was lacking or that more serious charges should have been brought, she says to them, is it my power, do I as the judge, do I have the power to ask or direct the U.S. government to redo the investigation or to bring different or more serious charges? She's totally setting them up right here. Do I have the power to bring new charges? Government says, no, I don't believe so, Your Honor. Of course not. Defense says, we agree, Your Honor. It would raise obviously massive separation of powers questions if that was to be taken. Obviously, right? It's like basic civics. The judge is making sure they're aware of this. So this is laying foundation, because she's going to hit him over the head with that in a minute. The court says, okay, and isn't that decision about what charges to bring for the prosecutor as part of the executive branch? Isn't that what that is? It is, Your Honor. So she's laying it on thick right there. Yeah, because it's from the executive. Yeah, I just wanted to be clear about that. I think that might come up later when we talk about this. And the defense attorney's like, yeah, it is. So he says, we concur, Your Honor. Great. The judge says, okay, yeah, that's exactly what I thought. So if there were a failure in the investigation or the charges brought were inappropriate, well, how would that get addressed in the form of our government? If there were a failure in the investigation, if the FBI rigged this thing, the IRS rigged it, the DOJ rigged it, how would that get addressed if there was a problem? And he's like, oh, that's interesting. Well, the government, who would obviously investigate that, right? Because they're the executive branch, which investigates these problems. The government, the prosecutor says, through the political process, Your Honor. What? Like we're going to vote for this or something? No, but that we were talking about this case. So yeah, the political process might reform the IRS or defund the FBI, but we're talking about Hunter escaping criminal justice. How do we fix it here? So the judge is probably eyes wide open at this moment, just going, what? Mr. Clark, the defense says, in particular, Your Honor, the executive branch is charged fully with investigating, making prosecutorial discretion decisions, and indeed, that's where the term prosecutorial discretion comes from. It's in the executive branch. And the judge is like, all right, okay. All right, let's walk through some of the provisions of the plea. A memorandum of the plea agreements. All right, she's ready to go. She says, Hunter, do you have it in front of you, sir? He says, yes, Your Honor. All right, it's 6 pages long. It has an attachment, Exhibit 1. That's 4 pages. Also attachment A. Now, A is not public. We don't see that. But I want you to go all the way back to the end of the document. All the way on the final page where there's 3 signatures on the final page. She holds it up. Is one of those signatures yours, Hunter? Yes, Your Honor. Okay. And when did you sign it? This morning, Your Honor. And before you signed it, did you have an opportunity to read it and discuss it with your attorney? I did, Your Honor. And are you satisfied with the advice and counsel you received during and regarding the plea agreement? I am, Your Honor. All right. Well, let's have a sidebar up here. Attorneys go up to the podium, up to the bench, and they have a conversation about attachment A. They go back. Judge judge says. All right, let's go back on the record, and I want to talk about the unsealed portion of the record. So, Hunter, now I'm going to ask the prosecutor to read the essential terms of the plea agreement. And Hunter, I'm going to ask you to listen carefully to what he says, because when he's finished, I'm going to ask you if the agreement as recited by him reflects the deal that you think and you believe you reached with the government. Okay? Mr. Weiss, the government prosecutor, is now going to read. Thank you, Your Honor. He's reading the terms of the plea. Paragraph 1 provides that Hunter is going to be waiving any challenge about venue. Okay, so Hunter's not going to challenge this case because he's going to agree to the case. He agrees to plead guilty to both counts. Paragraph 2 tells him what the maximum penalties are. And again, it's just notifying you of the maximum, doesn't mean what you're getting. Paragraph 3 describes the essential elements that the government would have to prove at trial. Knowingly, voluntarily admits his guilt to each one of these things. Paragraph 4 says Hunter is pleading guilty to these things because he is in fact guilty to these things. He actually did these things. We have a stipulation that there was a big loss somewhere between these amounts, 1.1 million, 1.3 million. Now they say subparagraph B, we're talking about the tax case, but we've got two cases and we've got two agreements, a diversion agreement, which is going to make the gun charge go away. Hunter doesn't get in trouble, complies with the terms of probation, maybe takes a class or whatever they say, charge goes away. The other one is the tax misdemeanors. So in this tax misdemeanor, we have subparagraph B. It says that conduct, which is set forth in the statement of facts, which is attachment A, to the diversion agreement that was filed. So the plea agreement on the misdemeanors is referencing the felony case, which will be filed today, does not constitute relevant conduct pursuant to the sentencing guidelines. And that if the United States does not subsequently learn about any other things, there's no increase in the sentencing. The court may make factual stipulations. They say that the United States is going to recommend a sentence of probation, so Hunter's not going to go to prison. And the rest of this stuff is boilerplate stuff, okay? Special assessments and so on. Now, paragraph 11 provides that the memorandum of this plea deal incorporates attachment A, which is filed under seal. The government, as Your Honor has said, routinely files these under seal, and we agree to be bound by attachment A. Paragraph 12 talks about restitution. Defendant agrees to restitution. Paragraph 13 talks about modifications. Now, the judge says, okay, thank you for reading all of that. Now, I have a couple questions about this, and she says the following. Paragraph 5A says that the amount of losses no less than 1,100. Well, actually, before we ask that, judge says, I want to go back to how any of this relates to the facts. Why don't you put Exhibit 1 on the record? Go read the rest of that. Says, yes, Your Honor, happy to do that. This is the government prosecutor. Says, at all times relevant to this case, Hunter was a lawyer and a businessman, lucrative, telling me, domestic and international business interests. From 2017 to 2019, served on the board of a Ukrainian energy company and a Chinese private equity fund. He further negotiated and executed contracts for business and legal services that paid millions of dollars of compensation through his domestic corporations, Owasco LLC. Through at least early 2017, he was also employed by a prestigious multinational law firm in an of-counsel capacity, which means they just really kind of probably wanted his name. For this work, he earned substantial income, totaling more than 2.3 million and 2.1 million in 2018. So he's kind of associated with the firm, but not really. Associated, really in name only. They say Biden also has a well-documented and long-standing struggle with substance abuse. Following the death of his brother in 2015, Biden relapsed and over time progressed from alcohol to abusing illegal drugs, including crack cocaine. This contributed to the collapse of his marriage, divorce finalized March 2017, as well as the collapse of his most significant professional relationship in 2017. Nonetheless, in 2017, despite his addiction, Biden successfully entered into business ventures, landed legal clients, earning millions of dollars. Amazing. By his own telling, in a memoir published in 2021, his substance abuse worsened in 2018, a year that included a move to LA and a spring and a summer of nonstop debauchery, or trafficking. Even during this period, however, Biden continued to earn money and exercise control over his personal and corporate finances. Tax returns and payments are due on the 15th. Biden, like many others, requested automatic extensions, pushing the due dates back to October. An extension of time to file a return, however, does not extend the deadline, which remained due. During calendar year 2017, Biden earned substantial income, just under $1 million from a company he formed with the CEO of a Chinese business conglomerate, CEFC. Look at this, $666,666 from his domestic business interests. Man, sometimes the numbers just work, don't they? Approximately $664,000 from a Chinese infrastructure investment company, $500,000 in director's fees. Biden is raking it in. From Ukrainian energy companies, $70,000 relating to a Romanian business, $48,000 from a multinational law firm. Throughout the tax year 2017, Biden worked with a DC and Maryland-based accountant to prepare his returns. In 18, his accountant, who died in 2019, wonder what happened there, prepared his 2017 corporate and individual tax returns for his review. Now, these efforts included contacting Biden, his assistant, his former business partner reviewed these returns, reminded Biden of his obligations. Despite these actions, Biden neither signed nor submitted his documents. Bummer. Not only did the accountant timely prepare these things and repeatedly encourage Biden to prepare and file, he advised him also to make his payments. He said, hey, Hunter, you owe $600,000, you owe $204,000 for this one. Biden said he could pay $25,000, but no payment was ever made. Liability kept growing. They established some sort of a payroll system to ensure that he had sufficient withholdings. But at the time of those withdrawals, there was a significant tax liability. Wonder where it all went. Large outstanding tax liability, profligate spending. They say he did, in fact, have funds available to pay. He got a $1 million payment from Owasco and into his bank account as payment for legal fees for Patrick Ho. Patrick Ho, I'm pretty sure, has been indicted by the DOJ for actual crimes or alleged crimes. Same types of things Hunter was doing. And $1 million remained available as of tax day. Now, over the next 6 months, Biden would spend almost the entirety of this balance on personal expenses, large cash withdrawals, transfers to his personal account, travel, and entertainment. Now, this is what is being agreed to even by Biden's lawyers. This is what they all wrote out. They're submitting on the record. So you can see the massive sums of money. Patrick Ho also listed in here legal fees associated with Patrick Ho. When Patrick Ho was on trial, he couldn't even mention the Biden name, even though they were in business together. So Biden continued to earn handsomely and spend wildly. He received a little over $2.6 million in business from somebody he formed a business with a Chinese business. However, without the structure of a stable business partner and still in the throes of his addiction, Biden ignored his tax obligations, withholding only $38 grand, 6% of the taxes owed. Biden traded emails with his DC accountant. He wanted an extension. He advised Biden of his obligation to make a tax payment, but the extension was filed, making the returns due. Biden, however, paid nothing. He continued to have substantial income, but didn't pay. Eventually, they received payments of about $758,000. By late May, Biden had spent almost the entire sum on personal expenses. Millions just going out the door. Large cash withdrawals, payments to his children, credit card balances, payments on his Porsche. After numerous programs and trips to rehab, Biden got sober. May 2019. Same month, he married his current wife. Remained sober since. Biden remained in California, spent much of his 2019 painting and developing plans for his memoir, which he began working on through the fall and the winter. This is, of course, when Joe Biden's gearing up for a presidential election, so the family is just in cleanup mode. During summer 2019, he was sued in 2 different domestic relation lawsuits, and he didn't make preparations to file his taxes. November 2019, got a tax accountant. He's like, daddy's running for president. All this accountant helps him with a bunch of stuff, signs a letter of representation. During this process, Biden miscategorized certain expenses. Yeah, I think like his legal fees were for a sex club, something like that. Personal expenses for sex clubs were legitimate business expenses. On February 18, 2020, Biden filed his tax returns, reported $2.3 million, self-assessed tax $700 grand, lots of money, numbers. Approximately a year and a half later, a third party, which I think is his bong lawyer, paid the IRS $1 million to cover the tax liability and another $1 million to cover another liability. $2 million from his bong lawyer. In addition, in or around Feb 2020, they discovered his 1040 from 2016 hadn't been filed. Big money on that one. 2016, $1.5 million. We've got extensions there, and that penalty was also fully paid by the same third party. So lots of money being paid off. Now, this is all just for the record. It's all just factual for the record. And the judge says, okay, all right, thank you. Thanks for putting all that in the record so we don't lose it. Now, I did have a few questions. She says, now, paragraph 5A says that the amount of loss is no less than 1.2 million and no greater than 1.5. Is that a combined loss or a loss for each count? That's combined. Okay. And in Exhibit 1, there's references to a third party who paid taxes. Those numbers add up to more than 1.9 million. Can you help me square that with the numbers here? She's doing some math. And the government is justifying all of this. They say, well, so the amount that was paid by the third party includes significant penalties and interest, which we have not included in the loss stipulation that's in paragraph 5A. The paragraph 5A is the taxes, and there's a dispute as to what those are. but this number is lost without inclusion of the penalties and interest. And we'll fast forward through some of this financial stuff. Is that standard here? Government says, yes, Your Honor. Defense, did you want to say something? Hunter's lawyer says, well, I was going to say it's a relevant guideline, Your Honor. For failure to pay a case, it omits penalties and interest and says, okay, if this were tax evasion, would those be included? It's my understanding that they would. Government agrees. Judge says, okay. Got that out of the way. So now I want to go back to this diversion agreement thing. You say that in paragraph 5 of this plea memorandum, it refers over to this other case. Remember, we're still in the tax case. So she wants to pause because 5B refers to this other agreement. That's the diversion agreement for a felony gun charge. Is that right? Government says, yes, Your Honor. And also here, she's flipping through pages. Also here, paragraph 12 refers to restitution and says that the self-assessed tax due at the time of filing. What does self-assessed mean? And he says, well, it means whatever this is. Based on all of this, a lot of process here, and that number is obtained by the IRS. And the judge says, well, okay, so this isn't, well, that's what I'm trying to figure out. Is there someone still looking into that to see if the self-assessed number is accurate? Or do you know that it's zero? Like, is this defined or not? The judge wants to make sure this plea agreement has no holes in it. Government says, well, the self-assessed number, again, it's the amount on the return plus the interest, blah, blah, blah. Defense says, Your Honor, look, to be clear, the dispute is we think it's lower. My understanding is all the monies that the IRS takes a position is that Biden owes a result of every tax year. It's already been paid. Hopefully that answers your question. Government says, so our position, Your Honor, is there are deductions that were taken that were improper. That's why for loss purposes, putting that aside, what the payoff number is, we'll address that at sentencing. We'll come up with the total number of money that is owed. The IRS will help us later. The judge says, well, okay, well, I'm just asking because you said it's expected to be zero. Why is it expected to be zero if you're telling me the numbers might be wrong? I mean, if it is zero, why don't we just say zero? That way we don't have to deal with it at sentencing. Government says, well, because that is the payoff amount that the IRS gave to Hunter, which is sort of a process that produces, that the IRS gave him. It's separate from what we're doing. Well, then why did you say you expected it to be zero? Because as the payoff number was given, at this time, there's no restitution owed to the IRS. Judge says, all right, so look, those are my initial questions. I may have some more as we go through this, and you better believe she's going to. But she continues. But that's what I had at the moment. All right, so she's looking at this. The lawyers are like sitting back down. They're like, all right, here we go. Mr. Biden, does the written agreement as summarized by Mr. Weiss, the prosecutor, that he just read all of that stuff, then we just hashed all that out, does that accurately reflect the agreement you have reached with the government? Hunter says, yes, Your Honor. Has anyone threatened you or forced you into entering this written agreement? No, Your Honor. Has anyone made you any promises that are not contained in the written agreement? He's looking at the document that she just had him hold up and say, I signed it, I read it, I'm not on drugs, I'm here. Has anyone made you any promises that are not contained in this written agreement? Hunter's lawyer springs up. Your Honor, with the exception of the diversion agreement, which is a separate document that we're not on yet, judge says, we're not making an exception. I want to know, has anyone made you any promises, Hunter, that are not contained in the written memorandum of plea agreement in front of us now? Defense says, yes, there are promises from the government in the diversion agreement, document 2. Judge says, okay. And sir, Hunter, are you relying on the promises made in the diversion agreement in connection with your agreement to plead guilty here on this one now? You're relying on those promises. Hunter says, yes, Your Honor. And if the diversion agreement in part 2, if that were not valid, if that were not enforceable for any reason, would you enter, Hunter, the memo of the plea agreement in this case? No, Your Honor. Judge is looking at both these lawyers like, all right, so we're going to discuss that agreement in a bit. But for now, let me say, and by the way, I didn't get a copy of paragraph 15 of the agreement, but the parties provided me with a copy of that agreement prior to this hearing today. So that's what I'm going to quote from at the moment. And this is curious because our question is, did they just sneak this paragraph 15 in here at the last minute? In other words, she didn't get it the day before. She just got it prior to this hearing. And so she's looking at this now. So she says, okay. Paragraph 15 of the diversion agreement states the United States agrees not to criminally prosecute Biden outside the terms of this agreement for any federal crimes encompassed by the attached statement of facts. Okay, facts. So we have a statement of facts, which is going to describe a bunch of the conduct that we read through, and that anything in there in that summer of debauchery, as he called it, whatever he was talking about, is included in the statement of facts, and that the diversion agreement is going to immunize him. The U.S. government agrees not to criminally prosecute Biden. Follow the bouncing ball. And this is something that was drafted by prosecutors at the DOJ. And so they're tucking this in multiple layers deep. Remember where we are. It's like nested bullet points. We have the main agreement, then we have the diversion agreement, and then we have an exhibit as an attachment that's a statement of facts. That's how far removed they're trying to bury this. The judge says that the statement of facts and the memo are trying to be filed the same day. This agreement does not provide any protection against prosecution for any future conduct by Biden or his affiliated businesses. So anything past, prior, immune, indefinitely, in perpetuity for. Statute of limitations, regardless, doesn't matter. If he commits new crimes, well, he's going to be charged for those. So the judge just read that and says, So, and just to be clear, I think you already answered this, Sir Hunter, but are you relying on that promise, this one right here, that very important one, in connection with your agreement to accept the plea in this case? That promise you think is relevant here? Is that true? Yes, Your Honor, says Hunter. Now, if that provision were not valid or not enforceable, Hunter, would you accept this plea deal on this case? No, Your Honor. If you had no immunity from the government, perhaps even a different prosecutor, and the government could bring a felony, let's say a tax evasion charge or a drug charge, if they could charge you later down the line, Hunter, would you still enter the plea agreement and plead guilty to these tax charges? No, Your Honor. So now the lawyers are all flipped. All right, now they go, our whole deal is getting derailed right now. This is bad. Train's off the track. Judge says, all right, well, so I need some help here then, because you all told me that this was a plea under Rule B and not under Rule A. See where we are at? She started this at the very beginning. But yet, I have this provision that I would think is normally in a plea agreement. So tell me, how do these two agreements relate? Are they part of a package deal? How is this working? Government's like, So, Your Honor, the United States position is that the agreements stand alone by their own terms, and both agreements include their last paragraph that says that with this one caveat, and the judge jumps in. He says, hey, this is a big caveat though. You're telling me that Rule B doesn't give me any authority to look at this. A refers to, having an agreement not to prosecute. That's why I'm looking at this. I'm not saying that you're wrong, but I need to understand this. Prosecutor says, sure. So, Your Honor, again, look, our view is that the plea agreement stands alone. There is no charge bargaining in the plea agreement, period. And that's what they have agreed to. The diversion agreement, she says, but he would not agree. We just heard. So just so I understand, sir, you would not agree to that plea agreement if you didn't get some immunity from other charges. Is that right? Hunter's lawyer pops up. Judge, speaking for my client, that's correct, Your Honor. She said, well, good. I didn't mean that to be a rhetorical question. So you're trying to tell me that's separate. But I think, and I understand why he's saying no. I wouldn't. I mean, that isn't separate to me. I need them both. So they're sitting here. They're separate, Judge. So just accept this one and that one. Well, no, he just said himself. They're connected. Government is still fighting for this thing because this is their crafted bag of excrement that they're trying to sell to this judge. Government says, well, that's the intention with the agreement he signed. She says, okay, so the intention of the agreement he signed was that it would be completely separate, and that if the diversion agreement were not valid or unenforceable and he were on the hook for the other charges, that he would still be pleading guilty? Prosecutor says that's right, because that's what the final paragraph of the plea agreement says he's agreeing to, that the plea agreement stands on its own without any additional promises outside the four corners of the agreement. And the court's like, the judge says, so obviously there's a disconnect here. You're telling me, it sounds like there are no promises outside plea agreement on the tax deal, but government, you just referenced this other addendum in the diversion agreement. So the judge is like, do you guys need to talk about this for a few minutes? You need to have a conversation with each other. Might be a good idea so you can figure this out. And the defense says, yeah. So judge says, okay, fine. How about I give you guys an opportunity so we can make sure we're on the same page on this thing? Because part of my charge here is to make sure that the defendant, Hunter, knows what he's pleading to. Defense says, we appreciate it, Your Honor. All rise. So they take a brief recess. All right, where are we? You guys had a big conversation with each other. What'd you hash out? The defense for Hunter says, Your Honor, I want to apologize for maybe my unartful phrasing for some of the issues that came up a minute ago. Perhaps I can explain Hunter's position in a way that might clarify a couple things for us. There are two agreements in this case. They're both very important to Hunter. One is a plea agreement that the court has before it. My client is ready to enter a plea. Please, for the love of God, let us. He's ready to enter that plea without contingency, without reservation, and without connection. So they had a talking to. They're like, Hunter, you got to enter this deal, bro. Let me see if we can squeeze this through. But there is another agreement, which is a diversion agreement, and the judge cuts him off. Right. So let me just ask you, if that diversion agreement were not valid or were unenforceable for some reason, would he enter this plea? He says he is ready to live by the terms of that agreement. Okay, but if that diversion agreement did not exist, he would be willing to live by the terms of this plea and plead guilty. Now, I have concerns about the diversion agreement, so I'm asking you, if it were not valid, if it were unenforceable, would he plead to the memorandum of the plea in this case? Judge, based on our understanding of the diversion agreement, which is a bilateral agreement between the defendant and the government, which the government has reaffirmed to me that it will stand by, then yeah, he would enter the plea. All right, this is backroom dealing on display. I couldn't see it better. Based on our understanding, he got confirmation from the prosecutor that they will not charge Hunter. The diversion agreement will be entered. It's an unspoken deal. They've reaffirmed to me they're going to stand by it, and Hunter will not face new charges. Now, the other thing that we notice is he's telling the judge essentially to get out of here, butt out. Judge, you can't intervene on this anyways. This is an agreement between the defendant, Hunter, and the government. There is no judge involved. They're deciding not to prosecute him. I've communicated with them. They're giving me assurances there will not be a prosecution. So therefore, I will take this plea deal on this first charge. The judge says, I understand what you're telling me. So you're not answering my question. You're saying, well, we think it's valid and enforceable. I'm asking you, if it were not, I know what you think. Go with me here. If that agreement were not valid and enforceable, if that agreement did not exist and he could not rely on it, would he enter the plea? Because the judge is saying, I know you guys think you're coming to this agreement about all this, but I'm about to blast that out of the water. He says, well, you're asking for a hypothetical for me, Judge. He says, well, yeah, I'm asking that because... And he cuts her off. He cuts the judge off, but she basically could have finished this and said, because I'm about to destroy your diversion agreement. But he cuts the judge off. He says, yes, Judge, my client would resolve this case on these terms in the hypothetical situation that exists without that diversion agreement, which means he has gotten assurances that there will not be additional prosecutions and that he thinks he doesn't need the judge at all. He's going to go do this backroom deal with the government. Prosecutors telling him this. Just go tell the judge we'll deal with this elsewhere. I want to be clear. It is the party's position that there is diversion between the parties, which is binding. So he says, Judge, when I take this out of your courtroom and I go sign this deal with the prosecutor, it is going to be binding. You don't have any, it's binding from our perspective. You don't have any standing to interfere with a private agreement between the government and the defense. He says, but take that out of today's proceeding and my client is ready to enter the plea under this agreement. They're trying hard to squeeze it through. The judge says, okay, well, let me ask you those questions again there, Mr. Biden, then, since you've had a chance to talk to your lawyers. And now she's looking at him again. And Hunter's, as a defendant, he's listening to his lawyer. He's going to change all of his answers. Like he said one thing 10 minutes ago, and let's listen. Let me ask you the questions again, Hunter. If the diversion agreement were not valid and enforceable for any reason, would you enter this plea deal? This is how bad they want this to go through. Hunter reverses himself completely. Yes, Your Honor. And are you relying on the promise in the diversion agreement not to prosecute you in connection with your agreement to accept this guilty plea? Are you relying on that? 10 minutes ago, it was yes. Now, no, Your Honor, because he's got assurances. And so if you had no immunity from the government through that agreement and the government could bring felony tax evasion charges, you would still enter the plea agreement and plead guilty to these tax charges? Yes, Your Honor. That's how strong the assurances were. The Department of Justice told this defense lawyer in no uncertain terms whatsoever, there will not be another prosecution coming out of my office. This will be the end of it. You and I will sign documents. we'll take it up. My bosses had to approve this. This has to go all the way up the DOJ because the defense attorney talked to Hunter, the president's son, and got him to reverse all of this. And Hunter, as we know, is going to be petrified. 10 minutes ago, I'm not signing anything. Are you nuts? Now he is. That's how we know the DOJ is not doing anything. They're trying to squeeze it through. Judge says, wow, all right. Well, now I want to talk about a little bit about this agreement to not prosecute. The agreement to not prosecute is in the gun case, but it also includes crimes related to the tax case because they're trying to sneak it into multiple layers. So we've looked through a bunch of diversion agreements that we have access to. This is the judge, and we couldn't find anything that had anything similar to that. We have a lot of cases that come through our courtroom here, DOJ. You're on a lot of them. We looked through a bunch of other diversion agreements and we couldn't find anything that had anything similar to that. So let me first ask, government, do you have any precedent for agreeing not to prosecute crimes that has nothing to do with the case or the charges being diverted? I'm not aware of any, Your Honor, because it's nuts. So what the judge is asking, you have an agreement number 2, which is about a gun. And in this gun charge, you're agreeing to not prosecute Hunter for evasion of tax crimes? Are you psycho? What are you talking about? Do you also want to include his prostitution charges in there, his money laundering scheme? Do you also want to include his dime bag of cocaine in there? It has nothing to do with the gun diversion. So why are you smuggling in all of these other charges? Have you ever done this before? The government themselves admit, I'm not aware of any, Your Honor. Never done it before. Okay, judge, okay. That's what I thought. Do you have any authority that says that that's appropriate and that the probation officer should agree to that as terms? Or the chief of probation should agree to that as terms of a diversion agreement? Do you have any authority for this? The prosecutor, Mr. Weiss, and we don't want to forget these names, or Wise, says, Your Honor, I believe that this is a bilateral agreement between the parties. This is between Hunter and us. Hunter's daddy's Department of Justice, okay? Stay out of it. Says, I believe that we've negotiated this in their best interest. I don't believe that the role of probation would include weighing whether the benefit of the bargain is valid or not from their perspective. She says it's the government and the defense. And so if probation's got a problem with it and this agreement, that's on them. And she says, well, all right. So have you ever seen, I think I just asked you this, but have you ever seen a diversion agreement where the agreement is not to prosecute, where it's so broad that it encompasses crimes in a different case? Have you ever seen that before? No, he admits. And I would say, Your Honor, I don't think it is broad in the sense that she says, we're going to talk about that. You can sit down now. I can feel this judge's fury. All right, now is an agreement not to bring charges. She asks a question. Is an agreement not to bring charges or an agreement to drop charges, is it typically something that's included in a plea agreement? The judge asks the government. He says, well, it can be. And if it were included in the plea, would that make this plea a Rule 11A plea? Government says, yeah, it would. She remembered. So in your view, that would change the analysis, wouldn't it, on what I need to do in evaluating to accept this plea or not. So you told me it was a Rule B plea. Then you tucked in a little provision that makes it a Rule A plea. And so you told me that I only had certain factors. Remember that? Rewind all the way back. But then you tucked this one in, and now you're admitting to me that it would make it a Rule A plea because you know the rules very well, because I asked you about the factors. So that would change the analysis, wouldn't it? This guy got busted so bad. Would that change the analysis, the one that you told me, you educated me on that I had to do here today? It's going to be different now because of something you included? Would it change it? It would. She says, okay. And so let's just understand this. If it were that, then my role would be to accept or reject the plea then, right? Under the original interpretation. Yeah, it would, says the government. What happens if I accept the plea? We go forward to sentencing then? Government says, yeah. And what happens if I reject the plea? Government says, well, then this is one of the issues with charge bargaining. He says, why? Because there's a waiver of venue? Well, there is a waiver of venue, but also it's been addressed in some courts. If the court were to reject a plea on its view that the charges should be different, the judge jumps in. Well, what if I were to reject the plea on the grounds that it includes an agreement not to prosecute? That, as we're going to talk about in a few minutes, I don't even understand the scope of. Government says, so she says, well, I mean, forget all the investigation. What charges were brought? Judge says, I think that the parties have made clear. I asked you about this at the first outset of this. You said we live in a system of separation of powers. Those powers are given to the executive branch, aren't they? Right? Government says, yeah, right. So I don't mean to violate the separation of powers or do anything unconstitutional, says the judge. I'm just trying to figure out what my role is and what the appropriate rule is that applies to all of this. Prosecutor sitting there pouting. He says, right. Busted. Judge says, okay, so I am trying to understand. Now, help me. If I were to reject the plea, I'm not saying I'm going to. I have not. For anyone in the back there, I have not made that determination yet. But if I were to reject the plea, just tell me what happens, Mr. Prosecutor. Can you help? He says, so then we have 2 charges against Hunter and they're misdemeanors. Remember, we're only in the tax case now. So he doesn't need to be indicted. We can go forward and there is a trial on the books on those charges. And there's a possibility that there could be additional charges brought. There's a possibility that additional charges could be brought. Huh? The judge says, related to the tax issues? Government says, yes. Now he's saving himself. And she looks over. She goes, whoa, that's different. Do you agree with that, Mr. Clark? What would happen? Again, I want to make sure I'm not saying that this is my decision, but if I do reject this, what's going to happen? Is your client going to get charged with more crimes? Is that your understanding? He says, well, I understand, Your Honor. I don't necessarily disagree. And Hunter's sitting right there. He's like, the hell's going on here? He says, I'm not aware of any additional charges that could validly be brought with regard to the tax charges. He's like, that's not what I thought. Again, without getting into the whole investigation, but I do think there is some context that's important here. He says, the U.S. Attorney's Office and me, we spent 5 years in meeting after meeting, hours, 10-hour-long meetings, going through my client's taxes on a line-by-line basis. And this is the disposition the parties came to after a 5-year investigation that was pursued with unbelievable diligence and doggedness. All right, now this lawyer is begging, basically. He's begging the judge now. The judge doesn't care about any of this. So first of all, he's like, we worked really hard. Judge, I don't care. I don't care how hard you worked on your unconstitutional plea. And so first of all, this lawyer says, I don't think that there are any other charges to be brought. I think, we thought that just like in any compromise situation, we had valid arguments with regard to these charges, but my client undertook to plead guilty to them because it was the right disposition for all the parties after all this extensive negotiation. And so, yeah, I think we would have 2 filed informations and the courts and the parties would figure out how to proceed on those charges. And that would be the rest of the process. And the judge says, all right. So you said that there might be additional charges, or to the government. She goes back over to the prosecutor. Okay. So she says, thank you for that little statement. So you said that there might be additional charges. And now she's rubbing both their faces in this. Are you at liberty to tell us what you're thinking those might be? Or is that just a hypothetical that there might be? He's like, it was a hypothetical response to your question, Judge. Is there an ongoing investigation here? He says, there is. Hunter's going, what? What? The court says, may I ask then, why, if there is an ongoing investigation, why are we doing this piecemeal? Bingo! That's been the open question for a long time. Is this a global resolution or not? Are you trying to button all this up in this one case? Government says, Your Honor may ask, but I'm not in a position where I can say. Okay, why don't you sit down? She says, so I think what I'm concerned about here is that you seem to be asking for the inclusion of the court in this agreement. You want me involved, but you're telling me that I don't have any role in it. And you're leaving provisions of the plea agreement out and you're putting them into an agreement that you're not asking me to sign off on. I need you to help me understand why this isn't in the written plea agreement. Defense attorney for Hunter stands up. Your Honor, if I may, Your Honor. I mean, the original conception here was something like a deferred prosecution, a non-prosecution agreement, which generally the court doesn't necessarily weigh in on. I don't think it was that. We're not asking the court to rule in any way on the diversion agreement. Of course you're not. The diversion, as far as I understand, has been approved by probation. You've arraigned the defendant on the instrument, and I believe the process will go forward. He's telling the judge, just let this go. Just let it go. It's all worked out. She says, well, we have to talk about the diversion agreement. I mean, you included me into the diversion agreement. You keep telling me it's none of my business, but you included me. So we are going to talk about that. We have two agreements. We have a plea agreement where you're saying, Judge, we're all here in front of you. We're here right now for Hunter to plead. You're saying, I don't even get to accept it. I guess I'm supposed to rubber stamp it under the Rule B that you cited. But then it would be a plea under Rule A if the provision that you put in there in the diversion agreement, which you do not have any place for me to sign, it's not even in my purview under the statute to sign, you put that provision over there. So I'm concerned that you're taking provisions out of the agreement of a plea agreement that would normally be in there. So I don't really understand why that is. Government says, oh, the bargain, Your Honor, that was reached by the parties was the plea agreement that's in front of Your Honor, which is a B, as I mentioned, where there was only a recommended sentence. That is the plea deal. Which is, well, it's not. Because you reference the diversion agreement in the plea agreement. You actually wrote it in there. He says, not in the plea agreement. She says, you do. I asked you if paragraph 5B referred to the diversion agreement, and you said yes. And he says, well, only insofar as it's not relevant conduct. You reference it in the plea agreement, right? But it doesn't incorporate it. And in the diversion agreement, you reference the plea agreement, right? Government says only a part of it. We're living like bizarro world. I don't even know where we are. The court says, okay, and you say that in the diversion agreement, when you say that there is not going to be any prosecution, you say that's not just prosecution on the gun charge, which is subject to the diversion agreement. The gun charge is why you have the agreement. But you also say in that document, no prosecution with respect to anything in the statement of facts, which is attached to the plea agreement in the tax case. Multiple layers. These documents are all referencing each other. The prosecutor's like, exactly. Yes, perfect. You got it. Judge says, all right. Okay. So I don't really understand. I don't really understand though, why that's not a part of the plea agreement. Why is it over there? Government says, well, because by the terms of the plea agreement, the only function, the diversion agreement, well, it has no function, but the parties negotiated that, their view, and it's their view. Probation can take a different view. Your Honor can take a different view, but their view is the firearms offense should not be considered relevant conduct for calculating the guidelines. It does not incorporate the rules. It says that this is not considered. And so I think practically how this should work, Your Honor, is if Your Honor takes the plea, sign the diversion agreement, which is what puts into force as of today, at some point in the future, if we were to bring charges that the defendant thought were encompassed by the factual statement tucked away in the diversion agreement or the factual statement tucked away in the plea agreement, Hunter would have immunity. So he could file a motion to dismiss those charges on the grounds that he already entered into a contract with the DOJ to not bring charges based upon this conduct. And he goes, that sounds great to me. And the defense is like, that's my understanding too, Your Honor. It's a contract with the DOJ. And the judge says, well, I don't understand. How can you have an agreement not to pursue other charges in the case, the misdemeanor case, and you say that is not a part of his plea agreement? He says, because the plea agreement does not include that. All right. Judge says, so let's talk a little bit more about this. To the extent that the agreement, she says, sit down now. To the extent that the agreement not to prosecute is promised, do the parties have some understanding of what the scope of that non-prosecution agreement is? Yes, Your Honor. No, tell me, like specifically, what does it include? What is the scope? I know you guys think you know what it is, but you two are in cahoots with each other, and I'm not liking what I'm seeing. So what specifically does it include? You said that there is an investigation. I don't know what that is, but you must know that if there are particular charges that could be brought based on the facts that there are. Prosecutor, still fighting for this thing, says, so I can tell you what I think we can't charge. I can't tell you what the ongoing investigation is. So for instance, I think based on the terms of the agreement, we cannot bring tax evasion charges. And for the years described in the statement, it says, I think we cannot bring for the firearms charges based on the diversion. The judge says, okay. So there are references to foreign companies, for example, says the judge, in the facts section. Question, could the government bring a charge under FARA, Foreign Agents Registration Act? Government says, yes, you could. Court says, that's interesting. I'm trying to figure out if there's a meeting of the minds here because I feel like that's not what the defense is saying. And I'm not sure that this provision isn't a part of the plea agreement, and so that's why I'm asking. Hunter's lawyers, Clark stands up. He says, Your Honor, the plea agreement, she cuts him off. Now, I need you to answer my question if you can. Is there a meetings on the minds on that one? Do you agree that he could be prosecuted for FARA? If I allow this to go through, could he be prosecuted for FARA? Hunter's lawyer says, well, as stated by the government just now, I don't agree with what the government just said there. This is all on the record now. This is all being smoked out. Judge says, so I mean, okay, these are contracts, and to be enforceable, you know, there has to be a meeting of the minds. So what do we do now, you guys? Government says, then there is no deal. Judge says, all right, well, I guess then the question is, where does that leave us? So what do we need to do? You guys need some more time to talk? Do you need me to set a date? We need to talk about a preliminary hearing since we didn't really need to do one with this agreement. Defense says, we're going to waive the preliminary hearing, Your Honor. As far as I'm concerned, the plea agreement is null and void. No, we're going to have to discuss things with the government. Court says, all right, so I think we're on the clock now. So what should we do? You want me to set a date for pretrial motions? You want to exclude a little bit of time? You have some time to talk. What do you want to do, guys? Clark says, well, I think we would need 30 days after the trial clock to figure out what's going on. Judge says, okay, yeah, all right, I agree. I know that this has come of a little bit of a curveball, but I think that having you guys talk some more makes sense, and we will exclude time up through 30 days before Labor Day. And we're going to exclude time. You guys get a status report for us by that time. Says, Your Honor, before we start setting dates and stuff, can we just take 10 minutes? The defense is going to try again. Can we just take 10 minutes and see if we can make some headway on this before we call it a day? The judge says, okay, no problem. Thank you, Your Honor. All rise. Court's in recess. We fast forward. We're back in session. All right, please be seated. All right, where are we? You guys had your break. Tell me what's going on. Your Honor, we have had some discussions between the parties. Hunter's lawyers talking. We're trying to clarify the understanding, and I just kind of want to summarize where we are. And if the government's lawyers want to correct me, they can. So the parties have taken the position, Judge, that the diversion agreement is a separate agreement from the plea agreement. The diversion agreement is a bilateral contract between Hunter and the government. Your Honor has asked the parties what their understanding of the diversion agreement is. I think there's some space between us on this point, but we're prepared to agree that the scope of paragraph 15 and the charges relate broadly to gun possession, tax issues, and drug use. So it's not going to be unfettered. It's going to be gun possession, tax issues, and drug use. Does tax issues include FARA? The court says, I don't know. So are you guys going to rewrite that, or is that going to be adjusted in the plea deal, or what? Well, the government says that's what it means, and Your Honor has asked for what the parties agree. She says, well, I'm just looking at the language of that. So you're comfortable with that's what that means, even though the language of that seems substantially broader? And he says, Your Honor, I just put on the record what I have. And he's like, I said what the limits were. So we did. We don't need to write it. We didn't just answer yes. So yes, you are comfortable with that provision, means that it only relate, and for what period of time? Government chimes in, says it would be for the period of time in the statement of facts. Both statement of facts. She says, help me with that. What are the dates? From the year 2014 to 2019 for the tax offenses, and admission of drug use in that period, and firearms obviously there as well. Okay, so Hunter, your defense, you agree that the agreement not to prosecute only includes the time from 2014 to 2019, only includes the tax charges and the drug charges and the firearm charges. Is that right? Defense says, yes, Your Honor. Okay, so you can be seated now. And they continue. The judge says, now let me take a look here. I mean, part of the issue that I'm having is understanding, regardless of whether this plea is a subsection B or subsection A, it has to be a knowing plea. Hunter has to know this. And I'm already faced with the defendant saying under oath, saying two things, both that he would not enter the plea if the diversion were not valid, and that he would enter the plea if it were valid. The old flipperoo, judge says, and so I'm a little bit confused about that. So I think we can work through that though. But let's take a look at some of the rest of this. All right, so Hunter, other than what we have just discussed, are there any other promises that have been made to entice you to enter this plea deal, Hunter? He says no. Do you understand that this is the time to tell me of any promises not in the record or of any threats that have been made? Because after today, you're not going to be able to withdraw your plea based on information that you could have shared with me here. You understand? Yes, Your Honor. Do you understand that the plea and the terms of the plea are merely recommendations to me? I can reject those, and I can do that without allowing you to withdraw your plea, and I can impose a sentence that is even harsher longer and more severe than anything you anticipate. I can do that to you. Do you understand? Yes, Your Honor. And are you pleading guilty of your own free will because you are, in fact, guilty? Yes, Your Honor. All right. Now I want to walk through some of the specific provisions of the agreement, Hunter. First, venue. You have the agreement in front of you? Hunter says, yes, I do. All right. So paragraph 1, it says you waive any challenge to venue. You understand that you could challenge this court. You could say this court's not appropriate. You're waiving that. Yes. By entering your plea, you're giving up that challenge. Hunter, yes. Did you discuss that provision with your lawyer? Yeah. Are you satisfied with that advice? Yeah. Okay, next. Mr. Weiss, you went over the maximum penalties for these counts. Hunter, do you understand the maximum penalties? Yes. Do you need me to go through them one more time? No. Paragraph 3 lists the essential elements of the crimes. Do you understand that if I accept your guilty plea, Hunter, the government's not going to have to prove anything. You're just going to agree that you're guilty. You understand? Yes. And it also references a statement of facts, Exhibit 1. Now, you heard Mr. Weiss read those earlier into the record, and that is something that is not common in my experience. I just want to ask you about some of those things. Now, I'm going to go through all of those facts, not all of them, but I want to ask about some of them because it's part of the plea agreement. Do you have those documents in front of you? Specifically about the facts in the agreement of not prosecuting you. I want to talk about those documents. Do you have those, Hunter? Yes, Your Honor. All right. So in the very first paragraph of Exhibit 1, Hunter's looking at this document on the defense table. It says towards the end, it says through at least early 2017, I think before that in the first paragraph. Okay, second sentence, it says here, from 2017 to 2019, Hunter, it says, you served on the board of a Ukrainian energy company and a Chinese private equity fund. Can you tell me what those companies were? Hunter says, yeah. The Ukrainian energy company was Burisma, and the Chinese private equity fund was Bohai, Harvest, and Rosemont. Judge says, and some of this I'm asking just so I understand, because there are other references to Ukrainian companies and Chinese companies, and I can't tell if they're the same company or not, so that's why I'm asking you. So later in that paragraph, it says, through at least 2017, you were employed by a prestigious multinational law firm in an of-counsel position. It says through at least 2017. What were the years? Do you remember, like, how long you worked there? Hunter says, Your Honor, I think I was at Boyes Schiller 2010. Maybe was when I started, but I'm not positive of that. That's what I believe. Okay. And were you in an of-counsel position the whole time? Yes, Your Honor. All right. And now it says that for the work you did, you earned $2.3 million in 2017 and $2.1 million in 2018. And you left in 17. Is that true? Yes. And now I'm trying to understand 2018. Tell me how 2.1 million, where'd that come from? She says, well, Hunter's lawyer says, Your Honor, my understanding is that sentence picks up the work described in the last couple of sentences, not just the work for Boyes Schiller. And he says, well, Mr. Biden probably knows. Maybe he can answer. Biden says, yeah, exactly, Your Honor. I believe that the government intended for that sentence was my total income, not just my work at that firm. Oh, okay. So for all of your work, for this work, it's all of the things that are listed above there. All right. Thank you. Thanks, Hunter. Okay. So in the next paragraph, it says that you have a well-documented and a long-standing struggle with abuse. And you did tell me already, so I'm not going to ask you again about your efforts to treat that. But when we talk about well-documented, is there a particular thing that we're looking at for where it's documented, or is that just based on your discussions? Like, is this, you said documented, is that somewhere? Well, I believe the government is referring to a book I wrote about my life struggles with addiction in that period of time, and quite possibly other news outlets and interviews and things like that. So in that paragraph, it refers to sort of the middle. It refers to your struggles with addiction that led to the collapse of your most significant professional relationship. Is that referring to the law firm or something else? Hunter says it's about my business relationships, all of my business relationships, ultimately including the law firm. I had a business that was Rosemont Seneca Advisors, and I had a long-standing business partner from the inception of that company that I started, and others that all collapsed during that period of time. Judge says, so one of the businesses was Rosemont Seneca. Were there other businesses that also collapsed? The one referenced here is called Owasco in your documents. Hunter says virtually everything collapsed. Owasco is the holding company for all of the other companies below there. Okay. And who was your business partner? Hunter says a gentleman named Eric Sherwin. Okay. And the fourth paragraph, it says during calendar year 2017, you earned substantial income, just under $1 million from a company you formed with a CEO of a Chinese business conglomerate. Is that the same or a different Chinese company from the one you referenced earlier? Hunter says, I started a company called Hudson West, and my partner was associated with CEFC, a Chinese energy company, the same one that Gal Luft is allegedly associated with. Who is your partner? Hunter says, I don't know how to spell his name. Yi Zhangming, the chairman of that company, who I believe has now disappeared into the depths of China. Is that company still in existence? Hunter says no. Okay, the judge says, then it says that you made this interesting number here. 666. $666,666 from your domestic business interest. Is that Rosemont Seneca? Yeah. And how about this amount? 600 grand from China. Is that another one? Yeah. How about this one? CEFC, 500,000? That was director's fees? You already told me about that one. Hunter says, yeah, that was Burisma. $48,000 from the law firm. Hunter says, yes. That's Boy Schiller? Yeah. All right. Now, the bottom of the first page, the final paragraph says that the accountant sent copies of documents to your business partner. Is that Mr. Sherwin who is receiving those? Hunter says, yeah, I believe that's the one who they're referring to. The judge says, all right. On the next page, let's keep going through this filing. Four lines down from the bottom, it talks about tax liability. Now, it says the end of year liability should not have come as a surprise. Do you see that? Hunter's flipping through the pages. I'm sorry, I'm just trying to find it. She says, that's okay. Take your time, Hunter. He says, yes, I see that. It's right here. It says, judge says, it should not have come as a surprise. It wasn't a surprise. Is that right? Yes, Your Honor. And you knew, well, I didn't write this, Your Honor. So the characterization, defense attorney chimes in. Can we elaborate the time there, Your Honor? Judge says, yeah, please explain. He says, okay, so essentially there was a tax treatment that was undertaken and it changed the tax treatment at the end of the year. So I think the point is, and I didn't write this either, there was substantial influx of income during that year. There was an issue with his last minute tax treatment change. So there were expressions at time of surprise at that. I think the government's point is, you know, you made a lot of money. It shouldn't have come as a surprise. And the judge says, okay, well, my only concern is when I read this as a lawyer, it shouldn't have come as a surprise. That doesn't preclude Mr. Biden from saying, yes, it did. And he says, yeah, Your Honor's characterization is exactly right. So you're saying it actually was a surprise, or did he knowingly do this? Did he knowingly do it, or was it a shock to him? Which one was it? In that year, it was a surprise. She says, okay, you guys are okay with that? Yes, Your Honor. Okay. But then she says to Hunter, but you did know that you owed tax money, right? Yes, Your Honor. And your business partner, he told you that no withholdings had been made? Hunter says, yeah, I believe that's the case. Okay. So in the third paragraph, which is actually the second full paragraph, it says on the March 22nd, 2018, you got $1 million payment. $1 million payment into Owasco as a payment for legal fees for Patrick Ho. Is that right? Yes, Your Honor. Who is that payment received from? Hunter says, was that the law firm? He says, no, that came in from Patrick Ho, Your Honor. Mr. Ho himself dropped you $1 million? Hunter says, yes. Judge is like, wow, were you doing legal work for him separate and apart from the law firm? Because he also had the law firm. Yes, Your Honor. Well, defense jumps in. Well, that wasn't through Boy Schiller, Your Honor. Mr. Biden was engaged as an attorney. She says, yeah, right. That's why I asked. You were doing work for him. He says, yeah, my own law firm, Hunter, not as counsel. So you had your own law firm as well. Hunter says, I think Owasco acted as a law firm entity. Yeah. So this judge is doing America a solid and basically deposing Hunter Biden for us right now, all for all eyes to see. Thank you, Judge. The court says, okay, I believe that's the case, but I don't know that for a fact. So the final paragraph, the judge says, on the second page of the exhibit says that you received a little bit more than $2.6 million in business and consulting fees from the company that you formed with the CEO. And I guess originally I was asking if that was in addition to the money you got from the other, if that was in addition to the money you got from the law firm. I think we clarified that. He says, yeah. So I guess what I'm confused about though, so is that 2.6 million, was that in 2018? That's our understanding, says the defense. But it says in the first paragraph of the exhibit for the work that you did for the Ukrainian company, that the Chinese company and your domestic business was 2.1 million. Defense is up again. Your Honor, I think actually for this one, again, we didn't write this, but we don't dispute its accuracy. I think this may summarize a chain of payments that was made over a couple of years. Oh, government chimes in. Your Honor, as I read that, the reference in the first paragraph is income, and it's more than, the language is more than 2.1 million. By contrast, Your Honor pointed out 2.6 million. So they're talking numbers. We'll fast forward through some of the numbers. The judge carries on. Okay, Hunter, moving on. Now, in the first full paragraph on the third one, It says, after numerous programs and trips to rehab, Hunter, you got sober in May 2019. Is that right? You see that? Yes, Your Honor. When I asked you earlier when you last used or were under the influence, you said June 2019. What was it that you did in June of 2019? He says, I was married on May 17, 2019, and that is my sobriety date. When I asked you earlier, he said, I was being conservative, Your Honor. I think that in between the date, to be technically and completely honest, from the day that I got married until June 1st, I did have a drink or two. So sober date, May 17th, had a couple drinks, official sober date, June 1st. So I count my sober date, at least in the program that you attend, as June 1st. So that's why I did that. Okay, so you said that the program you attend, I thought, are you attending he says, no, a separate program that required anonymity, like a 12-step program. Okay, but I'm just trying to make sure that we don't, Hunter says, no, I'm not saying that there are any programs that I'm involved in right now. I'm saying meetings that I go to, the sobriety date is often quoted, which is true at 12-step groups. You'll say, hey, I'm Rob, I'm an alcoholic, been sober 2 years, 5 years, 4 years, whatever it is. Hunter, his lawyer chimes in. He draws a distinction between treatment and a program. So like a 12-step program is different than inpatient treatment. The judge says, okay. And Hunter says, it's not that. And the judge says, I appreciate it. Okay, whether we call it treatment or something, you're doing to support your sobriety. Is that correct? He says, yes, Your Honor. Okay. Then that paragraph says that you did not make preparations to file or actually file. Is that right? Yeah. And taxes were due in October. Is that right? Yes. And you were sober at that time. That taxes were due in October 2019, right? Because you got sober in June. Yes, I was, Your Honor. But you didn't file your taxes. So this drug defense, what happened? He says, yes, Your Honor. In putting my life back together, it was a flood, an enormous amount of problems. And by the time I was able to find someone to help me, I was already past the deadline and I shouldn't have missed it. And at the next end of the paragraph, it says that in 2020, during the process of putting together your tax returns, you mischaracterized personal expenses as legitimate business expenses. What's that referencing, Hunter? The defense attorney jumps in. Your Honor, it may be better if I explain it because Mr. Biden's actually not that close to the facts. He just did it. In essence, it's in a very compressed time frame. Mr. Biden was asked to identify for all his credit cards expenses, business expenses, living situations, charts, all the things. Most of them relate to his account. He talks about getting the records, but the actual accountants couldn't get the records. So he says, we made some mistakes categorizing things, and that's what it refers to. Do you know the approximate amount of money of these mistakes? Well, that's the discussion in the dispute. It's around $30,000. It's not massive amounts of money. Mr. Biden's accountants erroneously overreported the income and so on. The judge says, okay, so just so I understand this, are these things that he made these mistakes and gave them to his accountant and then they were corrected, or he made these mistakes, gave them to his accountant, and then those mistakes ended up in the filing ultimately made to the IRS? Says it was the latter. All right, and Hunter, again, sir, all this was done after you were already sober. Is that right? Yes, Your Honor, it was. Judge continues. Okay. Now, I want to talk about this self-assessed tax. There was a third-party person who paid your tax liability. Is that right, Hunter? He says, yes, that's the same person. I took a loan from that individual. Oh, you took a loan? Yeah. Do you make payments on that loan? Not currently, Your Honor, but it's a normal, typical loan with terms and a time frame. Okay. All right. Well, let's talk now about paragraph 9. This is the appellant waiver provision. Says you can't appeal this sentence, Hunter. You know that? Have you discussed this with your lawyer? Yeah. Are you satisfied with the advice of your lawyer? Yeah. Now, I can read this waiver to you. Do you want me to read it to you? Hunter says, no, Your Honor. I'm confident that I understand it. Understand it's a broad waiver, right? It leaves little ability to challenge your conviction. You're waiving a ton of stuff. Do you understand this? Yes, Your Honor, I do. And do you understand that it is unlikely that any conditions that would allow you to appeal would adjust your sentence? Yes. She says, okay, this is a big one. I find that Hunter has knowingly and voluntarily waived his appeal rights. Now, as the government said earlier, Hunter, I want to talk to you a little bit about the sentencing process in federal court. It's not required in a misdemeanor case, but I am going to ask the United States Probation to prepare a pre-sentence investigation. before sentencing so I can see what's going on. Do you understand? Yes. Now, she says, when I get to sentencing, there are guidelines that allow me to go up or down in my sentences. The government agrees not to oppose probation, but I can't tell you if I'm going to agree with probation or not. Do you understand? Yes. Says, do you understand that if you're sentenced to incarceration, there could be consequences with probation? Yes, Your Honor. Do you understand that your sentence may include fine and imprisonment and all the things? Do you understand? Yes. Have you discussed this with your attorney? Hunter says, I have. And you understand, Hunter, that if I impose a harsher sentence, you will still be bound by this and you cannot withdraw. I understand. Now, I want to talk to you about some of the rights that you waive when you plead guilty. You understand if you plead guilty, and this is when the plea deal feels like it's back on track. They're going, we might get through this thing. You understand you give up the right to call witnesses? Yes. You understand that the government doesn't have to prove anything beyond a reasonable doubt. You understand? Yes. You understand that you're giving up the right to testify, to present evidence, to call witnesses. I give it up. Do you understand that you're giving up the right to a trial by a jury, and that you give up your rights to go to trial by entering a plea? Yes, Your Honor. Now, I'm going to ask the prosecutor to summarize for us what the government would prove if this case goes forward to trial. This is called a factual basis or a factual statement. Mr. Weiss says, Your Honor, I have read in its entirety the factual statement that we would be prepared to prove, already entered in on the record previously. All right, you want me to tell how that meets the essential elements? You want me to go through it? Yes, Your Honor. Says, well, you know what? I can figure it out, I'm sure, but why don't you tell me? And the prosecutor says, happy to. Says, Your Honor, if this case were to go to trial, here's what we could prove. Because remember, you can't plead guilty to something that didn't happen. You can't go plead guilty for a murder crime if there's no murder. They'll say, that's nice that you're kind of nuts that you think you did that, but you didn't. So did something actually happen here? They're detailing all the things that we already know. Hunter owed taxes, didn't pay taxes. All right, Mr. Biden, is there anything that you heard from the government that you wish to challenge about their proof? Hunter says, no, Your Honor. Do you disagree with anything they said about you not paying taxes? No, Your Honor. Hunter's lawyer, do you have any objections or concerns about what they just said? No. Judge says, okay, well, we're getting pretty close here now. All right, now at this point, and the attorneys are just like at the edge of their seats. They're like, this might go through. Holy moly. The judge says, all right. Now, at this point, I would normally ask Mr. Biden how he pleads, which is like the next sentence. Okay, and sir, how do you plead to the crime of? But she stops. As we've already discussed, the diversion agreement is out there in a felony case. It's cross-reference here. The plea agreement is also cross-reference there. And so before I ask him how he pleads, I need to understand. Well, I need to ask him how he pleads or decide if I can accept the plea agreement. Before doing that, I need to understand the diversion agreement. So the felony gun charge, she says, is a little bit unusual. And we don't usually make diversion agreements even public. And I don't see a diversion agreement as the parties up here have hinted. But in fact, you all did send it to me, and it is referenced in the agreement that is before me in the tax case. So she says it's a little bit unique in that I have a copy of the diversion agreement, and that the diversion agreement contains what I view to be some non-standard terms. Like, for example, it has broad immunity, and a term that invokes the court or involves the court in the agreement. They said the diversion agreement was a private contract between the government and the defense. So why is the court being involved? So given what I'm looking at, Mr. Prosecutor from Biden's DOJ, Mr. Weiss, why don't you go ahead and summarize the terms of diversion that you've agreed to? He says, happy to, Your Honor. The first, under Roman numeral 1, the parties agree that this is going with Hunter. The terms and conditions are for a 2-year period, 24 months beginning the date of the approval of this agreement. He would be on probation. Now, I think this is extremely, extremely sneaky, because I think that if Hunter was on this 24-month probation period on diversion, the DOJ would say this is an open case. And so they can't comment on an open case because it has not concluded yet. And that would give them, even at the conclusion of a plea deal, an excuse to not comment on this case, not send over records or anything. That's why they built this in. Paragraph 3 provides Biden shall waive the indictment on the gun charge, can't possess a firearm. He'll comply with all of the other terms. They say that we know that the government has probable cause to bring the charges. They talk about Biden's use of drugs. They say Biden agrees to waive any challenges on statute of limitations or other things, and that he's going to be bound to Delaware. He is not to violate any other firearms laws, and that the gun is forfeited to the United States. The judge says, okay, pause for a minute there. I forgot my glasses. and I'm going to ask someone in the back to get me my glasses. But I didn't want her to open the door and freak people out. So she says, all right, sorry. All right, go ahead. Got my glasses. Now, paragraph 10 and the subparagraphs says that Biden is subject to pretrial services and probation. Don't commit any new crimes while you're out on diversion. And he agrees to the statement of facts. And this is the procedure of a breach in paragraph 13. And this is where they bring the judge in. The United States believes that if there is a knowing breach of this agreement, they can go seek a judge's permission. They can go back to the judge for supervision of this agreement. The judge is going to say, oh, that's me. That's me. You want me to supervise this, so I better hear about it. Upon notice to Biden that the United States may seek a determination, Biden shall have the right to present evidence to rebut the claim. So it's almost like another charge is being developed. If after that process, the judge overseeing the process, which would ordinarily be a criminal process, if the judge makes a final determination that there was a breach of the diversion, they may elect for remedies. And the remedies are set here. The judge is going to flip over this. What are you talking about? If this is a private agreement, why are you involving me? So they bring in the rest of this document. And then paragraph 15 is the big one. This is the agreement to not prosecute. The language, the United States agrees to not criminally prosecute Biden outside the terms of this agreement for any federal crimes, immunity, or any federal crimes encompassed in the statements that they read earlier, which, as we saw, was extremely broad. Hunters and drugs, hunters got problems, tax problems, multiple business problems, China, Ukraine, all included in the facts. This agreement does not provide any protection for anything outside of this. They say, obviously, Judge, this paragraph has been orally modified by counsel for both of us. I'm not going to attempt to paraphrase it. The record is the record. Paragraph 16, general terms, paragraph 18, paragraph 19, and so on. That's the record, Judge. Says, all right, thank you. Defense, any corrections you want to make? No, Judge, sounds good to us. Now, the judge says, okay, well, the information charges Hunter with a violation of this law. Anyone have any concerns of this recent ruling? No. Your Honor, says, I think that case is relevant to actually why we have the disposition that we do here. And they continue. Says, so what happens here if this provision of the law makes it unlawful for a drug user to possess a gun? What if that were found to be unconstitutional? What if this is eviscerated? Government says, Your Honor, doesn't matter. It's a diversion agreement. It's a private contract. Doesn't matter if the law changes. Defense agrees. Same, Judge. I can tell you our intention would be to abide by the agreement and only raise any problems, but otherwise we're going to honor the agreement. He's like, we want this bad. The court says, but the problem is this. I've had 1 or 2 cases involving a person struggling with addiction who bought a gun. We usually see a felony charge for a false statement. The defendant admitted that his statement was false, but he wasn't charged. Again, I'm not trying to get into the purview of the prosecutor, and I understand the separation of powers. It's your discretion. But I just want to ask, does the government have any concern about not bringing the false statement charge in light of our discussion of the law? Why didn't you charge him with a more serious offense? Any issues with that, government? No. What are you kidding? It's the president's son. Why would we do that? They also ask about the statute of limitations and waivers of false statements. Can you tell me what would the statute of limitations be for false statement charges? They say October 2023, October 12th, 2023. Now the judge says, okay, thank you. All right. Now I've reviewed the case law. The judge says, I've reviewed the statute and I had understood that the decision to offer Hunter any defendant a pretrial diversion, it rests squarely with the prosecutor. And consistent with that, you've all told me repeatedly that it's a separate agreement. You said there's no place for me to even sign off on it. And as I mentioned earlier, usually I don't even see those agreements. But you all did send it to me. And as we've discussed, some of it seems like it could be relevant to the plea. One provision in particular stands out, talking about a material breach. Says, do I have this understanding correct that I would be brought back into this? So can you tell me how that might work? The government says, Your Honor, obviously the diversion agreement covers charges related to firearms. So if there was a breach, he could be charged with other things. Firearms charges, perjury, obstruction, stuff that's not barred. And the defense says, I think Your Honor may be asking about the functionality of your involvement. The concept was like the court could make a factual determination and then diversion would listen to your ruling. And the judge says, well, look, first I have to tell you, it got my attention because you keep telling me I have no role. I shouldn't even be reading this thing. I shouldn't even be concerned about what's in these provisions, but you have agreed that I will do that, but then you didn't ask me to sign off on it. So do you have any precedent for that? Like, has this ever happened before where you, like, I'm your private judge, where the government just has an agreement with the defense, and if it doesn't work out, you just give me a phone call and you, hey judge, can you settle this for us? You have any precedent for this at all? Your Honor, no, I don't have precedent. Judge says, yeah, I know. As I read it, tell me if I'm reading this correctly. It says, under the agreement as you all have drafted, the only way that charges could ever be brought is if I have the hearing that you all agreed that I have, right? You're just going to tell me that we're going to have a hearing now, and if I determine that there are charges to be brought, that's how this works? And the government prosecutor says yes. So they're like writing their own rules of criminal procedure. They're creating a private criminal inquiry track for Hunter. If anything else happens, he's gonna put up this agreement as a force field, and then this judge is going to decide, this Delaware judge, according to these knuckleheads' agreement. This judge is like, what are you talking about? Judge says, so if I don't have a hearing or make a finding, then no criminal charges can be pursued for any federal charge within the scope of this agreement. Is that right? Government, you're telling me that unless I find it, you can't do anything. The government prosecutor says, I believe that's right, Your Honor. I have neutered myself. So is there some requirement that you have that I have to make a finding that you all agreed that I would without asking? So is there some requirement that you have that I have to make that finding that you all have agreed that I would without asking? Kind of a confusing question, but this judge is probably furious. So, okay, so you're telling me that this is now my job based on what? Law? No. Okay. Government says, is there some, the judge says, requirement? Is there some requirement that I make that finding? Prosecutor says no. And you don't have any precedent for that, right? No, Your Honor. Do you have any authority that any court has ever accepted that or said that they would do that? Any court? No, Your Honor. This was crafted to suit the facts and the circumstances. Says, I'm concerned that that provision makes me a gatekeeper to criminal charges, and it puts me in the middle of a decision as to whether to bring a charge. And we already talked about separation of powers. I asked you about that at the very start of this hearing. And that choice as to whether or not to bring charges, that is the executive branch, not the judicial branch. So is this even constitutional, you two? But no charges. Usually in these agreements, right, Mr. Clark, the prosecutor says, we think he breached. And I don't mean to point it out. I'm not saying you're going to breach. I understand. We're doing a hypothetical. He says, I understand. The prosecutor says there is a breach, Judge. We got to move forward on the information. You then come forward and you're like, Judge, he didn't breach. Review this. Okay, so that's the standard. The government has, the executive branch has already made a determination. We're going to proceed with the charges. Now the government cannot make the decision to proceed absent involving the court. You're trying to drag me into this. Defense says, respectfully, Your Honor, I don't think that's the way it's structured. And I do think the way it's structured may get some way past your concern. In other words, you're wrong. What it is that it's not that the government has decided to bring charges. It's that the government believes there is a breach. In paragraph, they're being very clever here. In paragraph 14, the government brings the breach to Your Honor and says, we need a determination as to whether there is a breach of the contract. So it's like a civil pseudo-criminal thing. So it's not a question that we've decided what to opt into. We've decided what to do. We want it's Your Honor. We believe there is a factual dispute between the parties, not a breach. We would like you to make a factual determination. And she's like, I'm not your private judge, psychos. What are you talking? You're just going to come to me? Why can't you do that in the normal way? As I read this, the government has no discretion to bring charges if it believes that a breach has occurred, unless I opine. Defense says, Your Honor, can we approach and discuss this thing with this issue? Why? Because it's confidential? Yeah. Okay. You're going to have to make some showing as to why. I understand once we're in court in the Third Circuit, it's essentially strict scrutiny. So can you explain to me why this is something that cannot go on the record? Why do you have to come up here and talk to me? Say it now. It relates to plea discussions between the parties, which generally aren't publicly discussed. Okay, I will allow you to we'll have a discussion on the sealed portion, but you're going to have to convince me that it needs to be maintained as sealed, all right? Because I can't, it's hard for me to say that in the abstract if you're saying that's a plea discussion. Your Honor, defense says, let me try to handle it separately. There was a desire because there being, as Your Honor has seen, tremendous amount of political drag with this defendant, that the normal mechanism that might take place would have the protection of the court, not in the discretion to bring a charge, but in finding a breach, so that this would not become more politicized, but rather something that the parties could rely on, and we could have a neutral arbiter to determine the breach. The judge says, I understand, look, I knew why you brought it, okay? I could see why you would want that provision in here, but I don't. You are putting me in the government. The executive branch has the discretion to bring the charges. Here, the government does not have the discretion to continue to pursue this charge or any other charge unless you include the court. That's not how this works. And that seems like it's getting outside of my lane in terms of what I'm allowed to do. And thus, I have concerns about the constitutionality of this provision. That gives me concerns about the constitutionality of this agreement because there doesn't seem to be a separate severability. And that gives me concerns about whether the defendant has the protection from prosecution he thinks he's getting if this agreement turns out not to be worth the paper it's written on. Defense is scrambling. Your Honor, judge cuts him off. Your Honor, my concern is, and part of what I have to do is knowing involuntary. I can't let him. She's about getting ready to call it. I'm not convinced this is a plea under subsection B, but even if it is, all I have to say is it knowing involuntarily. I can't let Hunter plead to something thinking he has protection and he doesn't. Absolutely, Your Honor. I think my analogy to another hearing is a bad analogy. The government comes to the court. It says, Your Honor, we believe there has been a violation of supervised release. Unless you, judge, makes a factual finding that that's happened, we can't do what we would normally do, right? Scrambling. And again, it's the fact and then the discretion, right? And so here it's very analogous to that process, which is not a violation of separation of powers. I understand what Your Honor is saying. She cuts him off. I think I might need a little bit more on this because it is confusing to me. But concerning, I should say, is more than confusing. Not confusing at all. Concerning is the right word. Yeah, she nailed it. Let me ask you this. If the provision violates the Constitution, if this little scam unconstitutional agreement that you so-called prosecutors have concocted, let me ask you this. If that provision violates the Constitution, what happens to the diversion agreement? Well, if that provision violates the Constitution, the diversion, first of all, I'm not aware in a manner of which we can even challenge the diversion agreement, so it can't be unconstitutional. But if it did, I think we would say if it's unconstitutional, right? Judge says, the way I'm seeing it is the government decides not to be politicized. The government decides we're going to bring a charge and you say no. That's prohibited by the diversion agreement. And the government says the diversion agreement's unconstitutional. You don't have protection. So I'm not going to voice my concerns, you know. You're telling me we're not going to challenge it. That really doesn't. And Mr. Clark cuts her off. No, I'm not saying that, Your Honor. Under those circumstances, we would have a contractual dispute about this contract between the government and us that would get litigated like any other contractual dispute would get litigated. That's what this is. And she says, I know, but what if it is unconstitutional? What happens to the diversion agreement? It gets litigated in court. A judge finds that this stupid agreement is unconstitutional, or Trump wins and Biden gets prosecuted for tax evasion, and you now challenge this, and a judge finds and says, no, Trump can obviously prosecute him. No problem. This was a ridiculous thing. What happens? He says, well, I think it's valid, but for this provision. Okay, well, is there a severability provision? No, there isn't. But there is nothing that says it's unitary contract either. It's kind of half and half. There's no merger clause or severability clause. It's a toss-up on that, right, Your Honor? So if I say that I am not going to do what is requested, what you all have agreed that I am going to do, what happens to the diversion agreement if I reject what you want? If you're saying it right now in a binding manner, she says, no, I'm just asking you. I'm not making a ruling on any of this. a finding. I'm just asking because I'm trying to exercise due deliberation and consideration and make sure that we don't make a misstep. So, government, Mr. Weiss, if I say I'm not doing it, your contract has an impossibility in there because nothing can happen. I understand Mr. Clark might say that's fine, Your Honor, but the government, what happens if I say I'm not going to do it? You can agree I'm not going to do it, but I'm not? Prosecutor says, so in negotiating these terms out, we obviously agreed to, as Your Honor had pointed out, the executive branch has the authority to bring the charges. We have agreed to a limitation, if you will, that is predicated on the court taking certain action. If the court declines to take the action contemplated by the agreement, we would have to examine whether there's other ways to enforce this. And the defense says, and there is a way to modify the agreement between the parties, so a written modification could also happen. All right, she says, so what are you talking about? He says, I'm saying that if Your Honor said, I've determined this isn't proper, I'm not going to participate, we would work on a provision which says that we can modify the agreement. And says, Your Honor, I mean, I don't mean to hang everything on our analogies here, but I have done many of them in my life. I don't think it's unconstitutional. I think it's very fair. I don't think it is. I think if the court were to determine it was not appropriate, we could just modify the contract. And the prosecutor comes in. The analogy I would offer is that many other offices offer proffer agreements where a defendant and a witness and a target will sit down, and now the prosecutor is begging for this deal. So I think it's similar. Those agreements are also similar. And they're basically contracts, and we do this type of stuff too. These two people are begging. All right, judge says, I take your points. But I know I've asked if there was any precedent for this. I was told no. I was asked if there was any authority for this. I was told no. And I get the analogy, but I don't think I can on the fly, make the analogy that you're asking me to make, or even, you're telling me that this is appropriate. So I'm not sure what to do with that. It may be that you're correct and that that's an appropriate analogy, but it may be that you're not. Hunter's lawyer says, may I propose something, Your Honor? You don't have to. There's no action again not to. I know that you don't necessarily want to hear that all the time, that you have to take with a regular diversion agreement. Can I propose that Your Honor can take some time with regard to this provision, inform the parties, we can brief it for you, but again, I don't think that needs to hold up today's disposition. Those are just hypothetical problems. So let's enter this thing, and then if it pops up, we can clarify it. The judge says, well, the problem that I have, I'm not sure that it doesn't. Again, you're all telling me just to rubber stamp the agreement. It seems like the argument you're making is form over substance. Your Honor, all we're doing is recommending a plea. Okay, so she said the word Your Honor. That's why I got confused. She says, but it seems like the argument you're making is form over substance. What's funny to me is that you put me right smack in the middle of this diversion agreement that you say I should have no role in. You plot me right in there. And then on the thing that I would normally have the ability to sign off on or look at in the context, you just take it out and you say, Your Honor, don't pay any attention to that provision. Not to prosecute, because we put it in an agreement that's beyond your ability. But then you shove me in the agreement to fix it. So this is what I'm going to do, says the judge. These agreements are not straightforward, and they contain some atypical provisions. I'm not criticizing you for coming up with those. I think that you have worked hard to come up with creative ways to deal with this. Talk about creative. But I'm not in a position where I can decide to accept or reject the plea agreement, so I need to defer it. First, I don't know which rule this falls under. I'm not convinced this is a subsection plea deal. You all suggest is me just rubber stamping this. But even if it were, I have testimony under oath, both that the defendant is concerned about ensuring he's got immunity, but also that he doesn't need that immunity in the terms of the plea. So I need to think about that. It says, additionally, I need some understanding as to why this plea is under B, and my concern is about form over substance. I'd like some briefing, some additional on subsection B. It's going to be making it helpful for me to decide whether to take this or not. And then I would like, as you offered, Mr. Clark, Hunter's lawyer, you guys can go back and work on whether or not you can take out that provision and come out with something else that's acceptable. And while you do that, you might, though I'm not trying to tell you how to negotiate your deal, you might want to fix that one paragraph you've orally modified. Now, I would like to understand why that provision, if you want it to go forward, is appropriate. and why I am not doing something that gets me outside of my lanes in terms of my branch of government if I were to be doing that. Does that make sense? Makes sense, Your Honor. I think that the parties have been very eager to resolve this matter, and it has been pending for an extended period of time. And she says, it hasn't been pending for that long. I know when you guys first called, you said you would send me the agreements on a Tuesday or a Thursday. You wanted the hearing within a few days to cram it through. They wanted to shove this through so fast that it would make your head spin. She says, I couldn't even accommodate that schedule. But the fact this is our normal course of timing on things. And so I understand, and I certainly understand why you want to get this resolved, but I'm not in a position where I can do that now. So if you guys want to tell me when you're thinking we can get the papers that I'm asking for. Government says, Your Honor, what I anticipate is we'll need to order the transcript from today's proceedings. And I think we need to build in a little bit of time for us. So why don't we postpone this for a while? The judge says, okay, we'll move it. Fine with us, Your Honor. 14 days, fine with us. Defense says, I would say, Your Honor, we're also not asking the court to rubber stamp anything. Judge says, it certainly sounds like it. Tell me again why you think what my role is for the plea under 11B1B. It's not that I think the court's role. He said, I agree. I read the rule. The rule says I couldn't accept or reject. You're saying it's not a rubber stamp. So what is it I do here? Government says, well, you don't take action on the plea. Rule 11C says it's for B. Must be advised the defendant. The rule doesn't contemplate this, blah, blah, blah. Judge says, I certainly understand what if it's a plea agreement. I'm not going to just agree with you as to the limits of my role. You don't tell me what I'm not allowed to do. My problem is I am not. Says my problem is I am not sure. I need to understand the propriety. It may very well be that it is appropriate, but as I said, it did catch my attention. You throw me in there, judge, you're the gatekeeper, and then you take me out of the other aspects. You throw me into the diversion agreement, and then you take me out of the plea. So I cannot accept the plea today. I mean, based on what you just said, Mr. Weiss, Mr. Clark, if I want, I can accept a guilty plea where I defer my decision on the plea agreement, what the Supreme Court said is appropriate. Says we're pleading guilty pursuant to the plea agreement, so that would not be something that we would do. Basically a plea to the court. Does that mean I need to take a plea of not guilty? So you're not going to be pleading to me? So I better enter a plea of not guilty then, because you're not pleading to me. You're not pleading under this guilty plea. Better enter a plea of not guilty, right? Yeah, I believe so, Your Honor. All right. So, Mr. Biden, I know you want to get this over with, and I'm sorry, but I do want to make sure I'm careful in my view of this. Man, they're steaming right now. So I do need some more information, and part of this is making sure that your plea gets what you think it gets. And part of that is making sure that I do justice as I'm required to do in this court. So I need to get some additional information. I'm not saying I'm going to reject the plea. I'm not saying I'm going to accept the plea. I just need some more information. And so at this point, I'm going to ask you without the plea agreement, without me saying that I would agree to the plea agreement, how do you plead to the charges that we have been discussing? Hunter Biden says, not guilty, Your Honor. Thank you. So I will look forward to the parties' submissions. And after we have a chance to review those, we will either issue an order as to what we're planning to do with a plea, or we'll have a status conference and we'll get back here. Do we need to do anything else, anybody? I know that we talked about, being on the clock now. Can we exclude time? Yeah, I would imagine the court can exclude time. We agree, Your Honor. All right, we'll do that. And we'll see, and we'll get back to you. Now, Mr. Biden, I need you to stick around for just a minute after we adjourn. I need you, my deputy is going to ask you to sign this release order that we talked about. And then I need you to go downstairs to the marshal's processing and to catch up with probation. All right. Defendant says, yes, Your Honor. Anything else that we need to talk about while we are here today? Not on behalf of the United States, Your Honor. Mr. Clark? No, Your Honor. Thank you. Court is adjourned at 1:14 p.m. Monster filing. And this is a big one. I appreciate you sharing this transcript and this video with those around, because I think this is important to memorialize for the future. I do not think they wanted this to go this way, and I do not think that they are excited that it has gone this way. And so we, of course, will continue to cover. Thank you for subscribing as we continue to follow this. This case is now on the court docket, and it will have updates. We should have pretrial conferences. We'll have filings. We'll see what the government says as they try to backpedal and figure this whole thing out to save face, because the illegitimate prosecution could not have possibly been more on display in court. We had the government colluding with Hunter Biden, the Biden DOJ working with him directly to create this very abnormal deal, almost an offensive deal, that the judge rejected outright. And when she started asking them questions, the government prosecutor was trying to sell this deal as hard as any other defense attorney you've ever seen. And so we've got Leo Weiss, Derek Hines, Benjamin Wallace, all from the United States Attorney's Office, investigating Hunter Biden as so-called prosecutors, creating the most benign deal, try to squeeze this one through. And so we'll continue to cover, my friends. Thank you for subscribing wherever it is you're watching this, and we'll look forward to seeing you on the next one.